I'm asking if Ghana's judiciary is gradually becoming a tool in the hands of political actors.
Thank you very much for the question. Yes, Ghana has been experiencing new events with our judiciary, particularly with the CJ suspension. It is something that we have hardly seen for many years now. So it has really generated a lot of interest, for which reason a lot of people feel that our judiciary appears to be in the hands of political actors for various reasons, and it is a very serious matter. But when it comes to perceptions of partisanship, indeed, it is a growing feeling among the Ghanaian public that the judiciary, especially our Supreme Court, leans more in favor of the executive or the past government. That is a perception, okay? And when it comes to, for instance, high-profile or electoral cases, high-profile political and electoral cases, let's take these cases that occurred in 2012 and 2020 election petitions. It's part of some of the cases that have contributed to the perception. And also recently, when there were crises on the floor of Parliament, where some senior members of Parliament took petitions to the courts, all adds to that perception of Ghana's judiciary becoming a tool in the hands of political actors, okay? Then again, when you take judicial appointment, indeed, the 1992 Constitution outlines procedures for appointment as well as removal of judicial officers, including the Chief Justice. And the President of Ghana, under the Constitution, has been vested with that power to appoint judges to the superior courts, including the Chief Justice, in consultation with the Judicial Council and with approval of our Council of State. But while this is constitutional, I mean, when you look at the constitutional arrangement, it is provided. Sometimes the procedures or processes are criticized, and we have critics arguing that the constitutional arrangement opens our judiciary to political influence, especially if the appointments are not merit-based, but skewed towards persons who are seen to be loyalists to the appointer. Then again, on high-profile cases, some rulings in political sensitive cases have raised eyebrows. For example, on disqualification of certain parliamentary candidates, and the ruling on the compilation of the new voters register. All these things, whether perceived or real, okay, have also added up to the views held by some members of our public concerning the judiciary becoming a tool in the hands of our political actors. Then again, on judicial independence and integrity. Yes, as justices, in the course of their work, they're supposed to be acting independently, without any form of interferences, whether from within or from without. However, there is that perception that when it comes to judicial independence, because of the procedure in which they are appointed, sometimes out of pressures or for some interest of these same judges, instead of working professionally as desired, they tend to compromise on the issue of their independence and integrity. And they tend to they are blinded by their allegiance to the appointer, and they are affected in how they arrive at decisions. And so, again, apart from the point of partisanship perceptions in respect of cases that are determined, the procedure for appointment, and the issue of our judiciary becoming a political tool in the hands of political actors, we have also a role played by our media and the civil society, who from time to time also raise concerns about the executive overreach and the need for a truly independent judiciary to preserve our democratic governance system in Ghana. Despite all these perceptions about the judiciary being a tool in the hands of political actors, yes, to a large extent, we can say that the perception may be right or wrong, depending on how we perceive these matters. With the recent suspension of the CJ, many people again perceive it not as a tool in the hands of any political group, but rather as what? A constitutional mandate that is being executed by the specific persons mandated under the Constitution to carry out this function. Now, when you take our 1992 Constitution, the procedures for removing not only the Chief Justice, but also the other justices of the Superior Court have all been beautifully outlined right under Article 146, all the way from Clause 1, Clause 3, 4, 5, 6, 7, 8, 9, 10. When you read Article 146 of the 1992 Constitution, it spells out in a step-by-step format the steps the president, or even after the president receives the petition, the other steps that must follow. And since a petition concerning the Ghana CJ was presented to the president of Ghana, every step the president has taken so far, when measured in the light of the constitutional provisions and Article 146, as I mentioned, have all been what? Adhered to strictly, bringing to mind the rule of law, governance being handled in accordance with the dictates of the supreme law of Ghana. So when we say that indeed our judiciary is becoming a tool in the hands of political actors, for somebody like me, I may not want to agree totally with that kind of perception. But that's what I'm saying. Whoever agrees with this statement probably may be looking at what is happening from a different lens. But for somebody like me who is measuring every step of our political actors, particularly the executive that is in power, with respect to the actions they've taken so far on the suspension of the CJ, I would say that it is in line with what the supreme law of Ghana provides. Everything done so far is following through the rule of law, step by step. And so I would like to use this medium to disabuse the minds of any other persons who may have genuine concern to believe that indeed the judiciary is becoming a tool in the hands of the political actor because a CJ has been suspended. So this is my little take on the issue of whether Ghana's judiciary is becoming a tool in the hands of our political actors. Thank you.
Thank you too, lawyer. So